Please be advised that this recorded webinar has been edited from its original format, which may have included a product demo. To set up a live demo or to request more information, please complete the form to the right. Or if you are currently not on CSE Global, there is a link to the website in the description of this video. Thank you.
Hello, everyone, and welcome to today's webinar, First State Update, 2020 Case Law Developments and Updates to Delaware's LLC Act. My name is Annie Triboletti, and I will be your moderator. Joining us today are guest speakers Matt O'Toole, Chris Kelly, and Mike Maxwell of Potter, Anderson, and Corroon. And with that, let's welcome Matt, Chris, and Mike.
Annie, thank you. This is Matt O'Toole. Good morning, everyone. Thank you for joining us. Today we're going to cover case law developments and the recent statutory amendments to the Delaware LLC Act. And my partners, Chris Kelly and Mike Maxwell, will carry the laboring oar in terms of that discussion. And each of them is well positioned to discuss the topic that he's going to cover. Chris has an active practice in the Delaware Chancery Court, including a variety of LLC cases, and Mike has an active transactional practice addressing LLC issues, among other things, and he also sits on the committee of the Delaware Bar Association that is responsible for supporting our Delaware legislature in its efforts to keep the LLC Act and other business organization statutes current and up to date. So with that, I will turn things over to Chris to talk about recent LLC and alternative entity case law developments. Chris.
Thanks, Matt. Good morning, everyone. Today, like we've done in prior years, we're going to discuss three recent LLC and actually one limited partnership case that will, have potential ramifications and application in the LLC context that we'll cover today. The first case that we'll discuss today is the Sky Mineral Investors versus DXS Capital case. And that's a Court of Chancery decision where in that case, the majority members of a Delaware LLC, Sky Mineral Partners, brought suit against the minority members and others, alleging that the defendants engaged in a scheme to drive the company's operating subsidiary into bankruptcy in order to acquire its assets on the cheap. The court analyzed a defense motion to dismiss the complaint, and in its decision, the court granted in part and denied in part the motion. I'm not going to go into the court's analysis as to every claim, but we'll focus on the primary issues for our purposes today. According to the complaint, the company's operating subsidiary owned mineral deposits, and the company was trying to develop and monetize those assets, including securing a $30 million loan. The minority members who were defendants, their board representative allegedly learned that the mineral deposits were worth some $600 million. But instead of informing the board of that fact, the board designee allegedly informed certain minority members and their affiliates. Defendants allegedly entered into a scheme then to drive the subsidiary into bankruptcy in order to obtain the mineral rights cheaply. The minority members allegedly perpetrated this scheme by exercising their blocking rights to starve the company of capital, causing the subsidiary to default on the loan, thereby driving the subsidiary into bankruptcy, where an affiliate of the defendants purchased the assets. The majority members brought suit against the minority members, their affiliates, and the lender for breach of contract, breach of fiduciary duty, aiding and abetting, and fraud. The defendants moved to dismiss the complaint. The Court of Chancery rejected the defendant's argument that the court lacked personal jurisdiction over them based on the conspiracy theory of jurisdiction finding that the plaintiff's claims supported an inference that the non-member affiliates implemented a plan to starve the company of capital, drive the subsidiary into bankruptcy, and acquire the mineral deposits on the cheap, and that there were acts in Delaware to further the conspiracy to confer jurisdiction. With regard to the defendant's arguments that the complaint failed to state a claim, the court found that the plaintiffs adequately pled a claim for breach of contract against the defendant minority members due to their alleged breach of the confidentiality obligations under the LLC agreement, allegedly leaking the information about the mineral deposits to the non-member defendants. Regarding the breach of fiduciary duty claims against the minority members' board designee, the court found that the LLC agreement imposed by contract the same fiduciary duties as the common law, except for the corporate opportunities doctrine. The court then found that the plaintiffs had adequately alleged that the board designee used his fiduciary status as a manager to harm the company, noting that the designee allegedly leaked confidential information while concealing it from his fellow board members, and reasoning that a fiduciary cannot intentionally sit back while his company collapses so that the fiduciary's affiliate can buy the company's assets on the cheap. In regard to the manager's alleged breaches of fiduciary duty, the plaintiffs also alleged that the manager was acting as an agent of the non-member affiliates, and that therefore those defendants were liable for the manager's breaches of fiduciary duty. Based on an agency law concept, the court rejected the plaintiff's claim, reasoning that the plaintiffs failed to allege that the non-member affiliates had a right to control the manager or force him to take the wrongful actions. Rather, the manager exercised his own rights and obligations. As well, the court rejected the plaintiff's claim that the non-member affiliates were liable for breach of fiduciary duty under a control theory because they did not own any units of the company, appoint managers, or have blocking rights. In contrast, the breach of fiduciary duty claims against the minority members withstood the defense motion to dismiss, and we'll talk about this in a little bit more detail later. The court found that the minority members' blocking rights and the minority members' use of those blocking rights led to an inference of actual control over the company, and that they used their blocking rights in bad faith. Regarding the plaintiff's aiding and abetting claims, the court denied the motion to dismiss those claims against the non-member affiliates, finding that the plaintiffs had adequately pled the non-member affiliates' knowing participation in the alleged scheme to force the subsidiary into bankruptcy. However, the court granted the motion to dismiss the aiding and abetting claims against the lender, finding the lender was simply a third-party commercial counterparty that provided a loan at arm's length, got, quote, stiffed for $30 million, and then ended up having to sell the loan at a substantial loss, undercutting any inference of knowing participation.
Chris, this is.
Yep.
Go ahead. Sorry. Go ahead. I don't mean to.
No. Yeah, no. Go ahead, Matt.
Yeah, I was going to say that's a lot to unpack from this case. But does that conclude your overview of the case, or did you have more to say about it?
Yeah. So that's the summary of the case. There are some practice points that are important to note. For example, with respect to the board designee who allegedly leaked information to the other defendants and withheld that information from his fellow directors, allegedly, it's important to point out a few things. One, directors in certain contexts have disclosure duties to their other directors. So, for instance, Delaware courts have long held that there may be a duty to disclose that adheres in the duty of loyalty, such that the intentional failure or refusal of a director to disclose to the board a defalcation or scheme to defraud the corporation of which he has learned itself constitutes a wrong. The duty to disclose, as I mentioned, it may arise in certain contexts. It's not a general duty to disclose everything the director may know, but rather the director disclosure cases implicate circumstances in which the director may be personally engaged in transactions harmful to the company, but beneficial to the director or his affiliates. And so here there was a alleged intentional failure to disclose to the other directors or managers that there was significant value in the mineral deposits, and at the same time an alleged leak of that information to others in order to perpetuate this scheme. And so that was part of the court's basis for allowing the claim to withstand a motion to dismiss. At the same time, unpacking that further, directors and officers generally have a fiduciary duty not to misuse or disclose the company's confidential or proprietary information. And there was an allegation there in Sky that was done to further the scheme and to acquire the mineral rights out of bankruptcy on the cheap. And then a third practice point to note is that fiduciary duties may be owed by minority investors in certain contexts from the exercise of blocking rights. As we all know, generally minority stockholders or minority investors do not owe fiduciary duties. That's limited to directors, officers, and majority or controlling stockholders, and that minority stockholders generally do not owe fiduciary duties. However, there are circumstances where fiduciary duties may arise, and one of those is where blocking rights are exercised to the point where the minority investor channels the company into a particular outcome by blocking or restricting other paths that could lead to a finding that fiduciary duties were owed based on an inference of actual control.
So Chris, a takeaway for business planners, sort of picking up on your last point there, in the context of an LLC where there's contractual freedom, if you are representing a minority member who might have certain consent rights, there is the ability to craft, restrict, even eliminate fiduciary duties, right?
That's right. The common law fiduciary duties generally apply in the LLC context, but the Act, specifically 18-1101C, authorizes drafters of LLC agreements to expand, restrict, or eliminate a member or manager's duties, including fiduciary duties. The only restriction on that, as we know, is that an LLC agreement can't eliminate the implied covenant of good faith and fair dealing, which adheres in every contract under Delaware law.
So as usual with LLCs, the contract is king, and you better pay attention to the king.
That's right. So turning to our next case, that's the Walsh versus White House case. There, that was another Delaware Chancery Court decision which granted in part and denied in part a defense motion to dismiss. There, the claims were for breach of contract, breach of the implied covenant, and specific performance, where the court found that a buyout provision in an LLC agreement constituted a call option, and that once the company exercised that option to purchase a departing member's units, the company could not then withdraw from that contractual purchase process and refuse to purchase the plaintiff's membership units. So, turning to the facts of that case, the plaintiff minority members and the defendant majority member, White House, founded the company Defendant Carbon Visual Effects, LLC. The limited liability company agreement contained a buyout provision that stated in pertinent part that in the event that a member ceases to be employed by the company for any reason, the company shall have the right to purchase such member's units, and such member shall have the obligation to sell such units to the company. If the company invoked that right, the LLC agreement established a multi-step process for valuing the member's units. First, the company would select an appraiser to value the units. If the member disagreed with that appraisal, the member could identify its own appraiser. And in the event that that member's appraiser valued the units more than 10% higher than the company's appraiser, the two appraisers would jointly designate a third appraiser whose appraisal would control and bind the parties. So in 2018, the company elected not to renew the plaintiff's employment, notified the plaintiffs of the company's intent to repurchase their units, and obtained an appraisal. In response, the plaintiffs informed the company that they intended to seek their own appraisal. The company then changed tack, telling plaintiffs it was no longer exercising its right to purchase their units. Plaintiffs, however, proceeded with getting the second appraisal, which returned a value of more than 10% higher than the first appraiser's value, and requested that the company follow through and help identify a third appraiser. The company did not respond. Plaintiffs then sued the company and the majority member White House for breach of the LLC agreement, breach of the implied covenant of good faith and fair dealing, and specific performance of the buyout provision. Defendants moved to dismiss for failure to state a claim. In addressing the breach of contract claim, the court rejected the defendant's argument that the company's notice of its intent to purchase was a revocable offer, finding that the buyout provision was instead a call option that had two pieces. One, there was an underlying agreement in the form of the company's right to purchase the plaintiff's units under the LLC agreement, and then there was the collateral promise on the part of the plaintiffs in the form of their obligation to sell their units to the company. Though the company had the choice under the LLC agreement whether to accept the offer or not, the company was bound to the underlying agreement to purchase the plaintiff's units once it accepted the offer by invoking the provision. The court found it reasonably conceivable that the company accepted the plaintiff's underlying offer to sell their units by notifying them of its intent to purchase and by subsequently undertaking the first step of the appraisal process. Accordingly, the court held that the complaint stated a claim against the company for breach of the LLC agreement buyout provision. The court, in contrast, granted the motion to dismiss with respect to the plaintiff's implied covenant claim, holding that the buyout provision fully addressed the company's ability to withdraw from the transaction, and therefore there was no contractual gap for the implied covenant of good faith and fair dealing to fill. With respect to the specific performance claim, the court denied the motion to dismiss, rejecting the defendant's argument that plaintiffs were not willing to perform the contract because the complaint sought an appraisal process that would ignore minority and illiquidity discounts required by the LLC agreement that could result in a lower valuation. While noting that the plaintiff's interpretation of the contract so as to try to avoid those discounts was, quote, a reach, the court reasoned that by seeking specific performance, the plaintiffs demonstrated that they were willing to perform the contract. Lastly, the court granted the motion to dismiss the claims against the majority unit holder White House because it did not have any obligations under the buyout provision. So that's the summary of the Walsh case. I think, as far as the takeaways go, it's important to note that many LLC agreements have buyout provisions similar to the provision in the Walsh case, and that depending on the particular terms and language of the buyout provisions in the LLC agreement, once invoked by the company, there may be an obligation to complete the process depending on the precise language of the contract.
So the advice for a company that's exercising a call right or contemplating exercise of a call right, such as was involved in this case, might be look before you leap. And insofar as we're, again, talking for the benefit of business planners, there is the ability to draft those provisions in such a way as to provide some latitude for the company. Wouldn't that be a fair statement, Chris?
Yep, that's precisely right, Matt. Another point to note, and this is more of a footnote, is that with respect to the analysis of the implied covenant by the court, it's important to note that the implied covenant adheres in every contract governed by Delaware law, but that it is a narrow gap filler. And so if the contract expressly covers the issue at hand, then there's no room for the implied covenant to operate. So the court will not rewrite a contract simply because a party later wishes it got a better deal, and the implied covenant is rarely invoked successfully. And oftentimes it's not, for litigators out there, if you have a contract provision that precisely covers the issue at hand, it may not make sense to bring an implied covenant claim because it could suggest to the court that your case isn't quite as strong on your breach of contract case as opposed to your implied covenant claim. And so, be careful in bringing an implied covenant claim if you feel you have strong contract language that clearly addresses the issue.
Well, Chris, that's interesting because there is a rule, I believe, that insofar as a party is attempting to plead a claim for breach of the implied covenant, one of the pleading requirements is that the implied obligation is to be alleged with some measure of particularity. And I guess the practice point for litigators, apart from your appropriate caution about whether you want to go down that path in the first place, is that you really ought to be able to articulate an implied obligation to be pleaded, the breach of which should be pled, and you need to be comfortable that the subject matter of that implicit obligation is not in fact stated in the agreement.
Yep, exactly, and I think it, in the Walsh case, it is not always foreseen that. I think there's a fair interpretation of the case that this was kind of a unusual situation where the contractual buyout process was started and then it was halted, and so in that circumstance it's not unreasonable to have perhaps brought the implied covenant claim as an alternative ground, but in a general sense, if you feel you have strong contract language, and you can't, as Matt mentioned, if you can't articulate what the implied obligation is because the contract language is expressly covering the issue, then it may not make sense to bring the implied covenant claim at all and suggest that your case is weaker than it really is.
Right.
So turning to the third and final case we'll discuss today, that's the Delaware Supreme Court's decision in Murphy. And in that case, it was a 3-2 opinion by the Delaware Supreme Court, which reversed a Court of Chancery decision that the limited partner plaintiffs were not entitled to certain books and records because they were not necessary and essential to the purpose of valuing their ownership stakes. The majority of the court held that the limited partners were entitled to the books and records by the plain language of the partnership agreements without regard to the inspection statute set forth in 17305 of the Delaware Limited Partnership Act, or any showing that the documents were necessary and essential to the plaintiff's stated purpose. So by way of background, the plaintiffs were limited partners and had demanded books and records under Section 17305 of the Delaware Limited Partnership Act, as well as partnership agreement provisions for the stated purposes of valuing their ownership interest in the partnerships and for investigating potential wrongdoing and mismanagement. The partnerships had agreed to make many of the documents available aside from the other limited partners Schedule K-1s that were part of the partnership's tax returns. So the limited partner plaintiffs filed a suit in the Court of Chancery seeking, among other things, the other limited partners Schedule K-1s. In the Court of Chancery, the court determined that there was no credible basis to suspect possible wrongdoing, but that the plaintiffs had stated a proper purpose of valuing their ownership interest. The Court of Chancery further held, however, that the relevant provisions of the partnership agreements incorporated the proper purpose requirement from Section 17305, as well as the corresponding requirement that the requested books and records be necessary and essential to the plaintiff's stated purpose, which the court attributed to 17305 based on the many years of case law applying the analogous provision from the Delaware General Corporation Law, Section 220. The court found that the limited partner plaintiffs had failed to show that the other limited partners Schedule K-1s were necessary and essential to their stated purpose, and therefore had failed to prove an entitlement to the other limited partners K-1s. On appeal, the Delaware Supreme Court majority, by a 3-2 margin, concluded that the limited partner plaintiffs were entitled to the other partners K-1s under the plain language of the partnership agreement. Because the limited partners were entitled to the K-1s under the partnership agreements, the majority of the court did not address whether the limited partner plaintiffs would have been entitled to the K-1s under Section 17305 of the Limited Partnership Act, or whether Section 17305 incorporated the necessary and essential requirement analogous to the Delaware General Corporation Law, Section 220. In that regard, the majority specifically noted that whether a necessary and essential requirement should be implied to Section 17305 was an issue of first impression for the court, and that no Supreme Court case had applied the necessary and essential requirement of Section 220 in the alternative entity context. The majority declined to imply such a necessary and essential requirement in the partnership agreements, noting that courts should be chary about implying contractual terms that the drafters of partnership agreements could easily have expressly addressed. The majority found that the partnership agreements permitted limited partners to obtain books and records for purposes reasonably related to the limited partner's interest as a limited partner and did not expressly require satisfaction of a necessary and essential requirement. The partnership agreements specifically provided that limited partners were entitled to the full names and last known addresses of each partner, as well as capital contributions, partnership interests of each partner, as well as tax information. The specific identification of tax returns and capital contributions in the partnership agreements, in the view of the majority of the court, highlighted the importance of such information, and the majority found that the K-1s fell within the scope of the expressly enumerated categories of documents set forth in the partnership agreements. Turning to the dissent's view, they believed that the language in the partnership agreements, which tracked Section 17305, should be interpreted consistent with the statute because the parties would have expected that using that same language would lead to the same, not different results. According to the dissent, Section 17305 tracks Section 220, and the Court of Chancery had interpreted Section 17305 by looking to Section 220 for many years. The parties, therefore, in the dissent's view, would have understood Section 220's necessary and essential requirement as applying to Section 17305, as well as the partnership agreements, by their having used the same language. The dissent disagreed with the majority that the necessary and essential requirement did not apply to the categories of documents specified in the partnership agreements because such an interpretation would have provided the limited partners with an unconditional right to all of the documents listed for any proper purpose. Finally, the dissent disagreed that the general partner's decision not to have established standards for inspection of books and records provided the limited partners with an unconditional right to inspect documents for any proper purpose because it would be inconsistent with the requirement that the inspection be for purposes reasonably related to the limited partner's interest as a limited partner. And to eliminate the requirement that the books and records be related to the stated purpose, the dissent viewed would read the word "for" out of the partnership agreement provision. And so that's the Murphy case. And
Chris,
I think,
can I just jump in real quick? This is Matt. Just to address some of the questions that are coming in over the live feed, for purposes of clarification, Murphy is a limited partnership case. The question at issue involved the inspection rights of limited partners in a Delaware limited partnership, and the reason we're talking about the case here is not because it's an LLC case, but because quite possibly by analogy, given the similarities between the LP Act and the LLC Act, the result in Murphy could be applied in an LLC setting. So that's why we're talking about this case today. And the other point that I'll just note very much in passing is that the discussion of the corporation law in Murphy in interpreting the contract at issue and its background language from the LP Act raises the question of when it's appropriate to invoke corporate law in an alternative entity context like an LLC or limited partnership. Not always appropriate, but in a situation like this where there's similar statutory language, and in this case, language used in a contract, it may well be appropriate to resort to corporate law precedents and corporate law principles. So with that, in response to some of the questions that have come in online, Chris, while you were talking, I'll ask you just broadly in regard to Murphy, is this outcome in a divided Supreme Court decision, is this a surprising result in some respects?
In one sense, a little bit, and in one sense, not really. I think the case was decided based on the specific language in the contract, and the language of the partnership agreements was such that it was fairly interpreted as providing an explicit right to review the tax documents, and that would have included the other limited partners Schedule K-1s, which are may well be viewed as part of the overall tax returns of the partnership in the view of the majority of the court. In one sense, it was a little bit surprising in that the majority suggested that it was not clear that there was a necessary and essential requirement to, aside from an explicit right to review certain, specified documents. It was a little surprising that the court suggested that there was not a necessary and essential requirement in Section 17305. I think given the many years of the Delaware courts, particularly the Court of Chancery, looking to Section 220 precedent, which interpreted or applied a necessary and essential requirement, that there would be a similar necessary and essential requirement in 17305, as well as the LLC equivalent, which is Section 18305. So that was a little surprising. I would expect that question will be answered, at some point down the road by the court. My guess is that, and it's, just a guess. So my guess is that given the rich, precedent from the Court of Chancery of looking to Section 220, that the court will ultimately, find there is a necessary and essential requirement, but that's just my personal guess. And it's important to note that, as far as the other limited partners Schedule K-1s, as Matt mentioned, the contractual freedom provided by the alternative entity statutes provide a lot of flexibility to either specify what you want to allow your limited partners or unit holders in an LLC to be able to examine and inspect, and what they're not permitted to inspect. And so if you have partnership agreement or limited liability company agreement inspection or books and records provisions, it's important to take a look at them and update them to make sure that they fairly and precisely express what you want the rights of your investors to be with respect to inspection of the company's books and records.
Right. So Chris, the LLC that's named in the caption of the Murphy case was actually the general partner of the other defendants that were the actual limited partnerships, with respect to which inspection of books and records was sought. So Mike, just sort of to loop you into the conversation here, if you're advising a GP in the aftermath of the Murphy decision with respect to existing partnerships or with respect to new, with respect to new partnerships, as Chris was saying, you want to be careful about drafting. In regard to existing partnerships, limited partnerships, any sort of practice pointers that you would advise GPs to look at?
Yeah, look, I think Chris is exactly right as far as the contractual drafting and considering, look at your provisions, look at what you have in there. As this case demonstrates, broad contract rights are going to be enforced, and even if you are tracking the language in 17305 or 18305 and thinking that that's going to result in a necessary and essential requirement being read into that, I think, as Chris alluded to, that there's some surprise, I think, among some of the practitioners that wasn't the case. And clearly the court punted on the issue of whether it would apply to the statute in the first place, but I think as far as contract drafting, a lot of practitioners kind of took that view, and that's what I think the dissent was getting at. But yeah, so broad contract rights are going to be enforced, but to Chris's point, and I think to the extent that you have these types of provisions addressing books and records in your partnership agreements or LLC agreements, the key is to look at those provisions and to parse out what exactly the rights are that they're providing, and to consider whether there's an ability to amend or update those provisions to further express limitations on what rights should be provided. It's a little bit easier when you are first drafting a partnership agreement or an LLC agreement to provide those restrictions. 18305G and I think it's 17305F both permit you to restrict rights for members or managers to obtain information as in an original LLC agreement, but also in any subsequent amendment approved or adopted by all the members or in compliance with any applicable requirements of the LLC agreement. So to the extent that there's an ability to amend or update your provisions to avoid these types of results, to the extent that that's the desire, parties should consider that as well. And again, coming back to the necessary and essential point, since that is a point that's not necessarily clear now as to whether books and records under 18220 would apply to the statutes of 17305 and 18305, and then even further into the contractual language, even if it tracks those statutes, I would say go ahead and insert that in if that's something that you want to have as a limitation in your provisions, and to what types of books and records can be requested and have to be provided by the managers or the general partners. You should probably consider putting that in there expressly.
So at this point, we're going to turn things over to Mike to talk about the recent amendments to the Delaware LLC Act. And I thought, Mike, it might be helpful before you launch into the particulars of this year's amendments, maybe just provide a high-level overview of the legislative amendment process in Delaware, which I think is still somewhat unique.
Sure. Thanks, Matt, and good morning, everyone. As Matt said, we're discussing recent amendments to the Act, and I do think it's helpful to discuss the process because, as you can imagine, this year has been an unusual year because of the pandemic, but amendments were still adopted. And so looking at the process for adopting these amendments, the legislative process in Delaware relies on a public-private partnerships between the Legislative Assembly and the Delaware Bar Association, and specifically entity statutes in Delaware are handled by a corporate counsel, and LLC and related alternative entity amendments are reviewed and proposed by a subcommittee of that corporate counsel of the Delaware Bar Association, and those amendments, it's made, or the subcommittee is made up of practitioners from the Delaware Bar, representing a number of different firms, large and small. And so as issues arise throughout the course of a year or two, whether it's through cases or through practice, transactions or whatever it may be. As those issues arise and we find things in the statute that may need to be updated or clarified or wholesale amended or changed to work better or more efficiently, as those things arise, they're brought before this subcommittee and vetted and considered and discussed ad nauseum. And as that process winds through the subcommittee, in addition, I should mention that we also work with certain of the agencies, government agencies, for example, the Delaware Secretary of State, to consider updates and amendments to the various entity statutes that they may request. And so as these proposed amendments are brought in front of the committee, they're discussed, and as language is agreed upon and vetted throughout the course of the year, ultimately they're put into a bill format and submitted to the legislature for their consideration. And as part of this consideration process, leadership of the drafting committee will often go down and testify, meet with legislators, and as well as testify in front of the legislature and the various committees, answer questions and address any concerns they may have. And Matt has served recently as the chair of that committee, and so I know this year things may have been a little bit different, but Matt, did you testify or have to give any testimony via electronic means like Zoom, or was that process any different this year for you?
It was considerably different from prior years. There was no live testimony, and the input that the legislature sought from us on the Bar Association side was really limited largely to the paper submissions that we provided and sort of informal consultation, but there was nothing formal this year, all driven by the pandemic. But that, to go back to Mike's sort of larger discussion, this collaborative relationship between the Bar Association and our General Assembly really has yielded pretty good results over time, and Mike may allude during his comments to a particular instance where the amendments really derived more or less directly from sort of practical experience with our statutes, and I think to the benefit of the law by enactment of proposal of changes that really do offer practical benefits. So Mike, thanks for that overview. Why don't you turn to the particulars of the 2020 amendments at this point?
Sure. Thanks, Matt. Right. So the amendments adopted this year, a lot of these were really additional revisions or clarifications to the Act, including various updates to provisions that were adopted over the last couple of years, in particular last year regarding electronic signatures, as well as some clarifications regarding appraisal rights and updates to the series and division sections. There was also some updates this year to, as a preview to 18301 with respect to clarifying the requirements for admission of members. And just as a note, a lot of times the amendments are made effective as of a certain date because of the uniqueness of this year and how things were signed. The amendments this year became effective when they were signed. I think there was some uncertainty in when that would have actually happened, but this year it was July 16th, 2020, so most of the amendments are effective as of that date. So moving into electronic signatures and the delivery of documents, the amendments to the Act last year included the addition of provisions relating to the execution of documents by electronic signature and delivery of documents by electronic transmission. Specifically, Section 18113 established non-exclusive safe harbor methods to reduce certain acts or transactions to a written or electronic document and to sign and deliver a document manually or electronically. Specifically, any act or transaction contemplated or governed by the Act or an LLC agreement may be provided for in a document, and electronic transmission will be deemed the equivalent of a written document. Specifically, in 113A, this permits LLC transactions to be documented, signed, and delivered through DocuSign and similar electronic means.
Mike, this is Matt. Can I jump in real quick on that? So your slide refers to LLC transactions, and that is not so broad as to encompass all transactions that an LLC might engage in. So, for example, if an LLC were a commercial lessee and entered into a commercial lease agreement and wanted to handle that transaction purely by electronic means, would that be covered, the form of the agreement and the manner of execution be covered by these provisions in the LLC Act or by other law?
It would be by other law. So when we talk about LLC transactions, and I should caveat that with, that's not to say that other law wouldn't permit that to be executed by electronic means, whether it's the Delaware Uniform Electronic Transmissions Act, Transaction Act, or other law. But as far as LLC transactions, we're really talking about, consents, maybe a merger agreement that's not filed with the Delaware Secretary of State, things under the LLC Act that expressly require signatures or execution, subject to, there's certain exceptions under 113, but those are really the types of transactions that we're dealing with, and not necessarily a commercial lease or something outside of the LLC Act. So just because an LLC is a party doesn't necessarily mean it's an LLC transaction.
Thank you.
So, as I was mentioned, whenever the LLC Act or an LLC agreement require or permit a signature, and electronic signature is permissible mode of executing a document. And this has been clarified in the amendments this year. So previously, an electronic signature was defined as an electronic symbol or process that is attached to or logically associated with a document and executed or adopted by a person with an intent to authenticate or adopt the document. The definition was amended this year to mean instead an electronic symbol or process that is attached to or logically associated with a document and executed or adopted by a person with an intent to execute, authenticate, or adopt the document. And then a new sentence was also added to clarify that a person may execute a document with such person's signature, which includes a manual, facsimile, conformed, or electronic signature. The intent, of course, was really to further just clarify that a person may execute a document by using any type of signature that's contemplated by this provision. Jumped ahead too soon. Another consideration with respect to these provisions, just as background, further provide that unless otherwise provided in the LLC agreement or agreed to between the sender and recipient, an electronic transmission is delivered to the person at the time it enters an information processing system that the person has designated for the purpose of receiving electronic transmissions of the type delivered, so long as the electronic transmission is in a form capable of being processed by that system and the person is able to retrieve it. So what comes to mind for me is email as the information processing system. A few other points just to quickly recall and remember as we're dealing with electronic transmission or electronic signatures. 113A does not prohibit the conduct of a transaction in accordance with Delaware Uniform Electronic Transactions Act, so long as the parts of the transaction that are governed by the LLC Act are documented, signed, and delivered in accordance with 113A or otherwise in accordance with the LLC Act. So as we discussed, a commercial lease may be covered by DUITA, but would not be covered by the LLC Act. The 113A does not preempt any statute of frauds or other law that might require actions to be documented or documents to be signed or delivered in a specified manner. And 113B enumerates certain documents and actions that are not governed by 113A, which include, for example, documents filed with or submitted to the Delaware Secretary of State, the Register and Chancery or court or other judicial or governmental body of the state of Delaware, or a certificate of LLC interest or partnership interest. And when I say a certificate, I mean a certificate that represents an LLC interest. As you know, LLC interest may be represented by a certificate similar to what you would think of with respect to stock or other types of equity, but that's excluded from 113A.
Yeah, on the theory that when entities elect to have certificated interests, even today, that really means a piece of paper.
That's right. That's right. That's right. A few other points to think about here is 113B also provides that it does not create a presumption that such excluded items are prohibited from being affected by electronic or other means. It's just not covered under the Act. If an exclusion applies, however, 113 may not be relied on as a basis for documenting an act or transaction or signing or delivering a document. And one other thing to consider here is well, going back to the policy of the Act and the freedom of parties to really structure their agreements and arrangements as they see fit. If a limited liability company agreement may limit the application of Section 18113 by expressly restricting one or more of the statutorily permitted means of documenting an act or transaction, or of signing or delivering a document.
Mike, let me ask you a question then about that. Contractual flexibility, and particularly that somewhat atypical requirement that the agreement do so, in other words, modify the otherwise applicable rules expressly. So if you have an LLC agreement that provides for member action, say, or manager action, by a signed written consent, would that reference to a signed writing be enough, in your view, to displace the rules that would allow for electronic documentation and execution?
I don't think it would. I think you have to be more explicit and more express with respect to electronic. Just requiring a written documentation, and in fact, I think the Act addresses that it should be deemed a writing or a document, right? So just saying it should be a written consent in and of itself is not going to restrict or eliminate the ability to rely on 113. And I think you have to be more express to the extent that that is your intent.
Yeah, I think that's right. I think that the rule that was enacted is really designed to facilitate the use of these modern means of concluding transactions.
Right. I wholeheartedly agree. All right. So moving on to our next amendment and next slide, talking about contractual appraisal rights. So the LLC Act contemplates that contractual appraisal rights may be provided with respect to an LLC interest or another interest in an LLC in connection with certain listed transactions, including amendments, merger or consolidation of both an LLC or a registered series, division, conversion of an LLC to another business form, as well as conversions of protected series to registered series and vice versa, transfers to or domestications, or sales of all or substantially all of the LLC assets. Currently, or previously, I guess, prior to the adoption of the amendments, the rights, had to be contractually provided in an LLC agreement, an agreement of plan of merger or consolidation, or a plan of merger or plan of division. So it was permissive in that these rights had to be contractually provided. We've amended the Act this year really to clarify that the contractual appraisal rights as a default rule are not available with respect to an LLC interest or another interest in an LLC unless provided, again, in an LLC agreement of merger, consolidation, plan of merger, or plan of division.
So really, Mike, the amendment this year doesn't make a substantive change so much as just changes the nature of the rule from sort of a permissive provision to a default rule that really clarifies the state of play.
That's exactly right. That's exactly right. And so if you're involved in these types of transactions and you do want to provide statutory or appraisal rights, there are no statutory appraisal rights. You have to contractually provide those. And in M&A transactions, private equity, those types of transactions where this might come up, it's good for practitioners to remember that this is different than the DGCL where you might have statutory appraisal rights. Here you have to contractually provide for those. So moving on to our division, and then following division we'll talk about series. Not too significant of amendments this year, but as we talk about divisions, I do think it makes sense to just review generally the concept of division that was adopted a few years ago. As you may recall, Section 18217 was added to the Act to permit a Delaware LLC to divide into two or more separate and distinct LLCs, which enables LLCs with various assets to separate the assets apart, essentially like a reverse merger. Unlike a classic asset transfer to another entity, it allows the LLC to be split apart into smaller freestanding LLCs according to a plan of division that's adopted by the original LLC. The law does not require identical ownership or management, and by design, pools of assets can be reduced into smaller pools without needing to transfer the assets out of the LLC. Now, a division is effected pursuant to the adoption of a plan of division and filing with the Secretary of State a certificate of division and a certificate of formation for each new LLC formed pursuant to the division. Now, whether or not an LLC can be divided is subject to its LLC operating agreement. If the LLC agreement of the dividing company specifies the manner of adopting a plan of division, the plan of division shall be adopted as specified in the LLC agreement. If it's silent, the same vote for authorizing a merger, assuming that it's not prohibited, is the vote required. And if the LLC agreement is silent on merger, then a division is authorized by the holder of over 50% of the LLC interests. And when an LLC decides to divide, a dividing LLC must file a certificate of division and a certificate of formation with the Secretary of State. And the original LLC has the option to either continue its existence or terminate as a result of the division. As you might recall, following a division, each division LLC is liable for the debts, liabilities, and duties of the original LLC as are allocated to it pursuant to the plan of division, and no other division LLC is liable for such obligations unless the plan of division constitutes a fraudulent transfer under applicable law. If any allocation of assets or liabilities determined by a court to constitute a fraudulent transfer, each division LLC will be jointly and severally liable on account of such fraudulent transfer, which really incentivizes parties to not engage in conduct that might reasonably lead a court to determine that there's a fraudulent transfer issue. Any liabilities and debts of the original dividing LLC that are not allocated by the plan of division will be the joint and several debts and liabilities of all division LLCs. And so with that background in mind, amendments to Section 18217 of the Act have address what can be contained in the certificate of division that's required to be filed to effect a division. So recall in 18217H, there's a list of items. Let me move us over to that slide. You'll see that on the slide here, there's a list of items that are required to be included in the certificate of division. What was not clear was whether additional statements not listed in the Act in this provision were permitted to be included in the certificate of divisions. And so this section was amended this year really to expressly recognize that flexibility, that is, the flexibility to state such other information as the parties might want to include in that certificate of division.
Mike, why would somebody find it useful to take advantage of that flexibility and add optional non-requisite information?
Yeah, so I think, Matt, thanks. That's a good question. I think it's helpful for listing statements such as the allocation of the assets and clarifying which division company is succeeding to what assets, for example. As we'll discuss a little bit later towards the end of the presentation, a division of a registered agent business could require the successor of the registered agent business assets confirm it is the successor and in the certificate of division under Section 18104. Also, allocation of real estate assets in the certificate of division may enable parties in another jurisdiction to file the certificate of division without the need to create and file a separate deed as you're dividing those assets from the LLC, including real property assets. So there's a couple of different ways that could be used, and again, I'm sure there will be more creative uses for it as this is enacted and as practitioners take advantage of this flexibility in the statute. So we're now going to talk about series and the amendments to the series provisions of the LLC Act. Really very light amendments this year, but again, I think it's helpful for just a quick review regarding series LLCs generally. Recall that Section 18215 was added to the Act, I think, back in 1996, that provided that an LLC could establish or provide for one or more series of members, managers, LLC interests, or assets. A series being essentially an internal cell within the LLC that may have a separate business purpose, investment objectives, separate rights, powers, and duties with respect to specified assets and liabilities of the LLC. And the goal really in setting these up is to have inter-series liability protections so that the debts, liabilities, obligations, and expenses incurred or contracted for or existing with respect to a series are enforceable against the assets of that series only and not against the assets of the LLC generally or any other series of the LLC. Similarly, that none of the debts, liabilities, obligations, expenses incurred, contracted for, or otherwise existing with respect to the LLC generally or any other series are enforceable against the assets of a particular series. So really providing a liability shield among the series. And so a few years ago, I guess 2018, and made effective as of August 1st, 2019, as part of the amendments, new definition of series was added to the LLC Act so that the term series now refers to a designated series of members, managers, LLC interests, or assets which may but need not be a protected series or registered series. So a protected series really was, in effect, a change with some of the updates to 18215. A protected series is a series that would be established in accordance with 18215B. So really a change in the nomenclature used to refer to series already established under 18215B with some important updates, including one of which was to clarify that a protected series is an association for all purposes of Delaware law, including the Delaware UCC. Also, a new concept of a registered series was added to the LLC Act with the addition of a new section 18218, which has the same rights and powers and same inter-series limitation on liabilities as protected series established in accordance with 18215B. It's also an association under Delaware law. It's, however, distinct in a few other ways, including which a registered series is formed by the filing of a certificate of registered series with the Secretary of State, and accordingly was qualified as a registered organization under the Delaware UCC. So with that background in mind, the 2020 amendments to the Act amend Section 18218D4, dealing with registered series, to confirm that a certificate of registered series shall be promptly amended if the certificate no longer complies with the requirement in 18218E1, which really is just a requirement that the name of the registered series and a certificate of registered series begin with the name of the LLC.
Mike, so if I guess sort of the practical advice to derive from this amendment is if an LLC has registered series and the LLC is considering a name change, it ought to consider the ramifications of that name change not only for itself but also for its registered series, particularly if there are a lot of registered series, because there would be a lot of filings required to change those names.
That's exactly right. That is exactly right. You know, it may, yes, especially if you have a lot of registered series, because you may be filing a lot of amendments to deal with those issues. So definitely something to keep in mind. Again,
we are down to the last couple of minutes, I think, Mike. So if you can get us through the last couple of slides, and then we'll try to address some of the questions that have come in online during the course of the presentation before we hand things back over to Annie.
Sounds good. Yeah, I'll quickly tick through these last few slides. The admission of members, Section 18301 of the Act's been amended this year to confirm that an LLC agreement may provide for the admission of members in connection with formation. I think that was always understood. We provided some clarifying language there, as well as to eliminate any statutory requirement that a member's admission after formation is subject to admission being reflected in the records of the LLC, and to clarify that an assignee of an LLC interest is admitted as a member as provided under Section 18704A and not necessarily subject to other statutory requirements regarding admission. And really what this gets at, and I won't go into the details in Perry v. Newport, but in Perry v. Newport, the Delaware Court of Chancery had addressed admission of members and the requirements for admission of the Act. It was a complicated case, addressed a number of different things, but with respect to the issues involving the transfers of LLC interests, it essentially held that you were not admitted until, in the absence of express language in the LLC agreement, until the person's admission was reflected in the records of the LLC. And so what we've tried to do with the amendments to the Section 18301 this year is to really eliminate the requirement that, notwithstanding compliance with the requirements of the admission set forth in the LLC agreement, the timing of admission is not going to be effective until, or that there's no requirement that timing of admission be effective upon it being reflected in the records of the LLC. So there was some, I think, ambiguity and maybe some confusion as to how that would apply. So if you comply with your LLC agreement, the admission doesn't necessarily, unless otherwise expressly provided in your agreement, require that you list them in the records of the LLC for that admission to become effective. So really, just quickly taking through books and records, there was, as you can see on the slide here, a clarifying amendment to really just further enable electronic record keeping, switched it from being a conversion into a paper form rather than a written form, again, just clarifying changes. And then talking about registered agents, as we mentioned earlier in our discussion about division, registered agents, certain transactions require are deemed a change of the name of a person acting as a registered agent, including a merger, consolidation. As the statute's been updated with other transactions such as division, these have now been added to 18104 and just clarifying that, the conversion of a registered agent or a division of a registered agent in which the resulting person succeeds to all the registered agent business of such registered agent pursuant to the plan of division. And this gets back to our discussion on the certificate of division. It's as set forth in the certificate of division shall be deemed to be a change of name for purposes of these sections of the Act, so 18104B and 904C, which then require the registered agents to file certain filings to reflect that.